Welcome back. Well, some key players in the advertising, publishing, music and film industries are headed to the Apex Court to oppose the Copyright Amendment and Performer Protection Amendment bills. These opposing the bills say the legislation poses a risk to the future of the country's creative sector. Let's unpack what all of this means now. We're joined in studio by Rabbi Mashabela. He's a director at Mashabela Attorneys. It's great to talk to you. Thanks for coming in on a Sunday afternoon.
Good afternoon, Michelle, and good afternoon to the viewers.
So the two bills referred by the President to the Constitutional Court last year,
Yes.
Is the main sort of crux of the bill about bringing South African musicians, and we know the issues around their royalties have been ongoing,
Yes.
to bring that in line to sort of international norms and standards?
Absolutely, Michelle. It is, and one of the important aspects that were actually looked at in these bills were the issue of literary musical works, visual, artistic, as well as audiovisuals. If you look at the bill itself, it in fact aims to promote the interests of the creative space in general, especially the musicians, right? And if you look at the objections that the President himself had, or concerns that he had with these two bills, you understand that actually as a legal person, it was actually reasonable.
Yeah.
Because one of the things that he indicated is the retrospective effect of these two bills. Because what it actually, they impose, or rather what they suggest, is that if, for instance, Michelle has been an owner of a specific copyright, but then these two bills come into effect, for instance, today.
But I've been in the industry for 30 years.
Exactly. But then the problem is these musicians or these creatives will automatically then have an entitlement to the historic ownership of this so-called, this rights. So that's essentially what the President has said in relation to these two bills. But also, one of the important things that these two bills were aiming to achieve was to try and ameliorate the chances and the issue of the artists or creatives saying that they are dying paupers, so that they can actually be able to be given their royalties. But one thing, Michelle, that I've picked up is that the creatives, or the musicians in particular in South Africa, they don't seem to be appreciating the fact that they are collecting agencies for their royalties. There are agencies that are tasked with the duty to collect the royalties and hand the royalties over to them. So they need to appreciate that, and they need to go to SAMRA, then to go to SAMRO. There's also Capaso that also represent the interest of this.
Wait, so you're saying that royalties have been paid, but to the agencies?
Yeah, in fact, what I can tell you is that at the moment, SAMRO is sitting with over 300 million of those royalties. They are unclaimed. So if you look at these two bills, they aim to make sure that the royalties are paid, but in fact, the royalties already are sitting with some of these collecting agencies. So it's very important that the musicians, even as these bills are aiming to improve their lives in terms of collection of the royalties, they are collecting agencies that are sitting with the money.
Sitting with the money to what end? Because surely, if an agency is receiving money in the form of royalties that is due to me as an artist, they would notify me that for the month of January, February, whatever the case may be, or for this quarter of the year, you've received this much in royalties and this is what's due to you.
Yeah, clearly there is a communication breakdown, but what I know for sure is that SAMRO has indicated that they are sitting with a lot of money that is unclaimed.
But do they know who it belongs to?
That is the issue, actually, Michelle. It looks like the artists themselves do not know the processes that they need to use to access the money. At the same time, it looks like the collecting agencies are not communicating with whomever these royalties are supposed to be dispersed to. But going back to your question, that's the first thing. The musicians must know themselves. Actually, not only the musicians, the creative industry itself must know that they are collecting agencies, but at the same time, there must be an improvement in terms of communication so that these agencies and the artists can know exactly what they need to do to make sure that these royalties ultimately get to the intended recipient.
Is there anything irregular that you're picking up in the fact that these collecting agencies are receiving the money and not paying it out? I mean, 300 million rand just sitting there.
Yeah. Look, I wouldn't say that is irregular because I haven't done any investigation. But what I'm saying is there must be some mechanism that is put in place to make sure that these monies are actually dispersed to the right recipients. One of the things, Michelle, that if I could just go further in terms of the objections that the president has actually put forward to, as well as the general public, was the issue of making sure that this deprivation that the president is talking about in terms of the ownership, it is actually arbitrary. The president said the deprivation is going to be arbitrary because it's not justified. It is not in terms of general legislation, so it is going to be unfair. And then that's when the president referred the two bills to the Constitutional Court for a consideration or reconsideration of their constitutionality. So, but one thing that I think I need to just highlight, Michelle, especially relating to the creatives in general in this space, is that the creatives need to research and know the industry themselves. There are a lot of artists in the country. In Limpopo alone, we are sitting at more than 5,000 artists. And I feel that over and above these two bills that aim to protect their interests, they also need to understand the industry itself. They need to know that once they receive these royalties, they need to have certain skills and capabilities to make sure, for instance, I can just give an example. Brand management is one of them, very, very important, especially in the creative space. They also have to make sure that they capacitate themselves on an ongoing basis.
Financial
literacy, in fact.
Yeah.
As we've indicated that some artists are dying with less funds or nothing at all. So it's very important that they know issues such as financial literacy, how to save, how to invest.
And what is due to me?
Exactly what I said. You need to know what is due to you. But of great importance also, Michelle, over and above investing and saving, you need to know that you need to have a lawyer who is going to advise you when it comes to the signing of these contracts. You need to know that you need to have an accountant who's going to advise you as to how much you're going to pay over to SARS because you issue out invoices to someone else that you've provided a service to, and then how much
drawing up the interest, drawing up the invoice.
Absolutely,
itself, you know?
Absolutely.
Yeah.
Are you VAT registered?
Right.
If you are VAT registered, then you collect the VAT, and you have to pay it over to SARS. How much is that supposed to be, and how much are you paying the people that support you, and then how much is your income at the end of the day?
What can I claim back from SARS for my office
Absolutely.
workspace, for driving to gigs?
Yeah, and the artists must also understand that these are businesses.
Right.
They are not supposed to be acting or doing this as if this is their personal persons. They have to make sure that they are running businesses. And when you run a business, Michelle, as you know, you need to understand your operations, your marketing, what is your brand like, and all those other things.
Yeah, and I mean, things like you can't pay for everyday expenses like, let's say, your rent from your business account. You know, there are certain things, and we wouldn't know that. People who work in the media space, who work in the entertainment space, we don't necessarily know what we can and cannot do with the business that we have registered because we see that as our own money. Right?
Absolutely, absolutely. And this reminds me of, in the recent past, there were a couple of artists actually that were reported to be owing SARS a lot of money. And that's because now they have not gotten the advice insofar as businesses run, insofar as taxes are done as well, insofar as invoicing, insofar as paying the promoters as well as the people that are assisting them. So it's absolutely important. And I'm grateful that there are institutions in the creative space, in fact, that are promoting the continuous education training of artists. But one thing that I've realized, Michelle, is that they actually do not attend these trainings. In fact, in the recent past, the University of Limpopo, in conjunction with some other organizations, including Shine Bright, actually were arranging and organizing trainings workshops for the artists, but the big names did not show up. And these are the big names that normally would get into trouble because they collect a lot of money. They use this money whichever way they want. Ultimately, they're owing SARS, they're owing service providers, and so on and so on. But, Michelle, one of the most important aspects that have been dealt with in the Copyright Act and Performance Protection Amendment bills is the issue of fair use. The fair use is a legal concept that actually is an American-derived concept, which denotes, in essence, that you could actually not obtain a permission from a copyright owner, but then the court, at the end of the day, if there's a dispute, the court can actually say to you, if there is a dispute, of course, the court can say to you, well, I believe here there indeed was a fair use or not. Mm-hmm. Then there could be some kind of compensation that will be payable if there was an infringement. So that's where the actual outcry came from, especially from the creative space, that this is open-ended and it could be open to abuse by people who are just going to utilize the fair use, as opposed to fair dealing. So this is
what the Constitutional Court is going to decide
Absolutely.
Among various other things.
Among other things, yes.
I think one of the other important issues that you've also raised, Rabi, is the issue of having a lawyer present when you are signing, perhaps with a new label. And I think that's particularly dangerous. I'm sure you will agree. If I'm a young and upcoming artist, I've been trying to sign with a label. I now finally get that opportunity to sign. And that's what I do. I just go ahead and sign. There's no scrutiny of the contract itself, what is due to me, etc. That's incredibly dangerous.
Look, the law says you are bound by whatever appears above your signature. Now, if you have not read and understood the contract, you'll be bound by it.
Sure.
And that's what I'm saying is absolutely important, that before any artist, any creative could sign anything, be it a publishing contract, be it a sound recording contract or any other contract, it's absolutely important that these creatives, artists, invest in consultation with lawyers, consultation with accountants, so that they can know exactly what they are getting themselves into. Now, there are a lot of artists that are locked up in prolonged or long contracts, and they're actually not happy in those contracts.
How long, for example?
3 years, it could be, and there are options, for instance, or clauses in the contract that say this contract is subject to an automatic renewal, and you are not
as it is.
As it is.
As it's signed.
And the law, in some instances, allows that. So it's very important that once you need or you are being called and there's an interest from Michelle Entertainment to sign you, call an attorney, consult, this is the copy of the contract, and I would like to have you to have a look at this contract. And they have a look at it, they advise you, let's remove this clause, let's retain this, let's negotiate this, and let's look at the royalties. What percentage of royalties should I actually be agreed to? All those. And so it's very important. Sure. It's a specialized area. But one other thing I think that is important, Michelle, is that this industry is very important because it does not only contribute to the social cohesion, it also contributes to the economy. In the recent past, it has been reported that South Africa alone, this industry contributed almost 3% to the GDP, which is about 161 million rands. So it's very, very important that people take it seriously, because this could also play a very important role in the economy.
So, Rabi, if indeed the Constitutional Court, whichever way it decides, and it is retrospective, how far back would we go? And if I have royalties due to me from decades ago, I mean, is that possible, or would there be a limit on how retrospective it is?
Well, at the moment, Michelle, the legislation as proposed are not quite clear. But one thing for sure, they have a retrospective effect. That actually, those are some of the things that we see as problems or problematic clauses, and they must be dealt with. And I believe that this legislation, the two of them, actually, there might not have been a need actually to have both of them. But it's important that there be amendments, because these are almost 60-year-old
Sure.
pieces of legislation. So it is not quite clear as to how far back one would go in terms of the retrospective effect of this legislation.
But important whichever way you look at it. Rabi Mashabela, let me thank you for your time this afternoon. Director with Mashabela Attorneys, as we look into the Copyright Amendment Bill and the Performers Protection Amendment Bill, particularly as it pertains to South African musicians and their royalties.